judges,
defense lawyer and
defense
prosecutor.
lawyer, prosecutor, retired lawyer. Ladies and gentlemen, it's a great honor for us to be here today. And this is the effort of Professor David Kassouf. He has his effort, and all of us are here together with the esteemed group of judges, lawyers, defense counsels, etc. Normally when the judge comes, we rise. Today, there are only exceptions. The judge comes and she sits down herself. Okay, the judge is here. So, in short, welcome. Hope you all enjoy. And again, thanks to Daman and all the efforts. And of course, our Assistant President, Jackie, who always works very hard to put this together. Thank you.
Thank you very much, Dr. Dubey. So before we get started, just some housekeeping rules. The washrooms are at the entranceway in the foyer. Please take a moment to recognize where the exit signs are in case. Today's program is being videotaped and will be uploaded to the VOB YouTube channel tomorrow. And now we can start the program. As Dr. Lewis said, I am the Janti Ramkumar, the President of the Lakshmi Sabha and the Assistant Executive VP, and I'm very happy to be representing VOB at this event. Just to give some context, VOB started a long time ago with the mandir as a place of worship, and following the Sanatan Dharma. Sanatan Dharma has been the way of life in use for many thousands of years. And the knowledge and learning includes spirituality, rituals, mantras, philosophy, astronomy, science, community health, and wellness. So today, this is part of community, this is part of the social issues that we are having, and we want to bring awareness and education to that side of the social issues. To introduce our MC today, she studied law at Osborne Hall Law School, where she won the Entrance Scholarship Award in 1990. Hira, since 1992, practiced law as Crown Counsel with the Ministry of the Attorney General. Hira's practice was in IT acquisitions, procurement law, contract law, and intellectual property law. She was head counsel for the Ministry of Transportation's Commercial Lawyers Group, providing advice to MTO's billion-dollar procurement, and earned her several awards for her creative, innovative, and solution-oriented legal approach, including her work on the Presto Card project, vehicle emissions, and record camera projects. Hira recently retired from her position at the Ministry of the Attorney General after almost 31 years, and is looking forward to new ventures to apply her legal education and experience, including giving a voice in her community to social issues such as domestic violence, youth mental health, and organ donation. Ladies and gentlemen, and youths in the audience, I introduce Hira Ramlakhan as MC of the program.
Thank you very much, Janti. And Janti is, as Baba said, she is the force, the female force, the Shakti of this temple, and one of the many, but a very powerful force here. Thank you, Janti. A woman is murdered every 2.5 days in Canada due to gender-based violence. Approximately every 6 days, a woman is killed by her intimate partner, and I'm not making these statistics up. It's based on my research. Domestic violence, also known as intimate partner violence, IPV, refers to multiple forms of harm or abuse caused by a current or former partner or spouse. Domestic abuse may be physical, it may involve stalking, emotional or psychological abuse, sexual violence, spiritual abuse, financial or economic abuse, or cyber violence. Most people who are committing abuse, and even the people who are suffering abuse, do not even realize that they are. The World Health Organization runs intimate partner violence as one of the major global public health concerns. While men too can be victims of domestic violence, and I want to make that clear, women account for most of the victims, with most of the perpetrators being men. Children, and this is, I cannot overemphasize the impact of violence on children in the home. Children can be victims and the impact can be severe, long-term. Children are present and they witness domestic violence in the home, 80% of the cases, too many cases. Statistically, children who witness domestic violence at home have twice the rate of psychiatric disorders compared to children from non-violent homes. Boys witnessing their mothers being abused are 5 times more likely to themselves be abusers. Girls witnessing abuse is also 3 times more likely to be victims of domestic abuse. And if that doesn't shake you, what would? Children who witness their mothers being abused are more likely to suffer from PTSD. Recognizing the need for intervention, in June of 2011, the Voice of the Vedas, Vishnu Mandir, initiated a domestic abuse initiative. The purpose was to create awareness of this huge issue and to provide education and provide families with any needed support that they may wish to have. It was very difficult, and it continues to be difficult to speak about domestic abuse in our community and in all communities, not just in the GTA, not just provincially, not just Canada-wide, but globally. Nevertheless, the VOV established a partnership with the Yellow Brick House in Richmond Hill, because this is where we are situated, to help to educate the community as well as providing a safe haven for female victims of violence escaping with their children from a home where abuse is occurring. So this conference today is yet another effort to bring the issue of domestic violence to the forefront. I have the privilege and honor this morning of introducing our panel of experts, and they are people who in their careers, they face and come face to face with domestic violence. With us this morning are prominent members of the Ontario bench, the judicial bench, their judges, as well as 2 members from the Ontario Bar. In no special honor, we're truly fortunate to have with us the Honorable Justice Sheila Ray, and maybe with hands so we know, Justice Sheila Ray, Justice Sonia Hemani, Defense Lawyer Michelle Johal, and Assistant Crown Attorney Rashmi Kumar. Just to tell you a little bit about the panel, the Honorable Justice Sheila Ray has been described as having a prescient voice, a trailblazer. She was acknowledged as the first South Asian Canadian woman appointed to the bench to be a judge in Ontario. That's a significant development. Her honor is the recipient of the 2020 Orem Award, an award which celebrates distinguished alumni from Dalhousie University who's made a difference in their communities and around the world. Her recent article, which is an interesting one, An Eye for an Eye, What Does It Mean?, was described by the editors of the Canadian Association of Provincial Court Judges as thoughtful and providing compelling insights into the origins and the underpinnings of lex talionis, which is an eye for an eye type of justice. As an example of a visionary insight, she has been including recommendations of Aboriginal sentencing circles into probation orders since the early days of her appointment to the bench, which I take would be relevant where the people before court were of the Aboriginal background. Justice Ray has been a judge of the Ontario Court of Justice, presiding on criminal matters since April 1992. Prior to becoming a judge, she was a legal advisor to the Federal Department of Justice on criminal justice and regulatory reform initiatives. She was also Labor Litigation Counsel at the Treasury Board, and she had a general law practice. So, Her Honor, I'd like to welcome you. Justice Sonia Hemani graduated with She graduated with a Bachelor of Laws degree from Dalhousie as well in 1999. Her Honor was called to the Bar of Ontario in 2001. Justice Hemani completed her Articles of Clerkship at the Peel Crown Attorney's Office in Brampton. Her Honor remained with the Crown's Office as an Assistant Crown Attorney until December 2001, at which time she commenced her 11-year career as an in-house legal counsel with Peel Children's Aid. From 2012 to her appointment to the bench in 2015, Justice Hemani established a general family law practice, which included panel work with the Office of the Children's Lawyer, representing families involved in child protection proceedings, and assisting families impacted by domestic violence. Since her appointment to the bench in 2015, Justice Kamani has been presiding over family law matters in the Ontario Court of Justice in Brampton. Please welcome Justice Kamani. Defense Counsel, Michelle Johal. She obtained her law degree, her Bachelor of Arts degree at UFT, and she attended Queen's Law School. She started practicing criminal law in 2005. We notice a common theme here is criminal law, with a firm in Toronto where she worked there for 7 years and appeared at all levels of court in Ontario. In 2011, she left the firm to start her own legal practice. Michelle has successfully defended individuals charged with offenses ranging from theft to homicide. She's a member of the Criminal Lawyers Association Board of Directors. She's been sought out by media to talk about legal issues, including the very famous The Agenda with Steve Bacon. And if you don't watch it, you should. Interesting show. She's also been featured on CBC News and CTV News. She's been a panelist at several continuing legal education programs of the Law Society of Ontario, the Ontario Bar Association, the Criminal Lawyers Association, and the National Judicial Institute. She's currently a lecturer at the Trial Advocacy Program at Osgoode Hall Law School. So welcome, Counsel. Rashmi Kumar is an assistant Crown Attorney at the Newmarket Crown's Attorney Office. Prior to joining the Ministry of the Attorney General, she was a criminal defense lawyer representing individuals charged with a wide array of offenses. She was one of the founding members of Cannabis Amnesty, a not-for-profit organization advocating for the expungement of cannabis-related convictions. She currently sits as a board member of the South Asian Legal Clinic of Ontario. She obtained her Juris Doctor or Law degree from Queen's University. So welcome, Counsel. Moderator, Daniel Kissoon, he's no stranger to us. He graduated from Queen's University in 1989 with the LLB. This was after he obtained an economics degree from York University and a law degree in the University of Kent in the UK. So don't try to figure out when he restarted his practice, you will never get to that. And so we were speaking to him. Damon was invited to teach at Queen's Law 1 year after graduating in 1990, and he's currently there as well, continues that practice as an adjunct professor. Damon is the principal of the law firm Kissoon & Associates since 2000, but prior to that, he was working in association with other lawyers. He's very active in the community, as we all know, by sitting on the boards of charitable community organizations. He's revived and hand over the proceedings to moderator Damon Kissoon. Thank you.
Thank you so much, Hera. So Hera, one correction. Justice Ray was the first South Asian judge to be appointed anywhere in Canada. Give her a big hand for that. So those of you who came in early or a little bit later, there's a fact situation that we'll be relying upon with respect to the discussion today. A young man came from India, he's a student, he got married, didn't get his papers, got into drinking, assaulted his wife. Immigration is on the line. He's charged. There are 2 young children, and we will be discussing the issues that arise or has arisen from that fact situation. The young wife is panicking and calling the police and the Crown's office and victim services. She wants the charges dropped. He's the only breadwinner of the family. Madam Crown Attorney, you're the one to make the decisions. Tell us what steps and all kinds of wonderful things you will do, and then the defense lawyer will say what she will do to get the charges dropped. Rashmi.
Good morning, everyone. So this fact pattern is unfortunately very common when it comes to domestic cases and criminal cases in general. I was telling Michelle, like, well, just pull up my Punjabi, very loud voice, but is this better? Are you? Okay. So yes, unfortunately, very common fact pattern. We see this quite often. I think across the board in the Crown's offices, where one intimate partner will call the police on the other because there has been some sort of altercation at home. The first thing to know is the police do not have any discretion when it comes to laying charges, especially when it comes to domestic violence cases. So if a partner calls the police on the other, and some sort of offense is made out, there will be a charge laid. So the fact that Ronnie called and essentially disclosed to the police that it was some sort of assault that took place and some sort of threat that was uttered, the police's hands were tied. They were required to arrest and charge Roger or Raja, however you want to conceptualize him. From the Crown's perspective, we are bound by the Crown prosecution manual. What it essentially has is separate policies that are in place for different kinds of criminal cases. So under the IPB policy, our first and primary focus is the public interest and public safety. Domestic cases, as you all probably know, are very emotionally charged. Partners are very emotionally, obviously invested in their relationships. And so there is a layer of concern that victims of domestic violence will come forward after the charges are laid, and because they rely on their partners, or because they love their partners, or there's family pressure from in-laws or other elders in the family household, that they will retract their statement and they will pretend like nothing happened. So when we're considering charges in general, we have to err on the side of caution and put the public safety first. So that is my primary concern as I'm making this fact scenario. Other things that I'm thinking about are the fact that the children were present at home when the assault took place, the fact that a weapon was used is not the ordinary sense of the definition of a weapon that I think of. It's not a knife or a gun, for instance, but anything that is used as a weapon may actually meet that definition under the criminal code. The fact that the complainant is quite vulnerable at this stage, it appears as Professor Kizuna indicated, she's not working Roger as a primary winner. The immigration stuff, I'm considering all of these issues. I take it that he doesn't have a criminal record, it's not a fact pattern, I'm also considering that. So when I look at this fact pattern, it's likely that this was screened for what's called early domestic intervention. The accused person, whether it's the female, the male, or whichever partner is in the relationship, who's the charged person, would go through the PAR program, which is the Partner Assault Response Program. They would do counseling for domestic violence situations, essentially conflict resolution. And after successful completion, it's likely that this charge will result in what's called a peace bond, which is a criminal version of a restraining order. If the charges were, let's say the shoot was some sort of, let's say it was a knife, and let's say there were serious injuries, or the assault was a little bit more aggressive than what's laid out, the Crown may seek a guilty plea, and that may be a conditional discharge. I'm sure Michelle will go into the details of that a little bit more as well, but that's essentially a finding of guilt, but it's not a conviction. It stays on your record for a limited period of time, and then it disappears. But the most important aspect of this is the police are always going to have a record, regardless of how this charge is dismissed of or disposed of at the end of the day, whether it's withdrawn or it's a guilty plea. The police will always have a record that they were called on a prior occasion to this home. And so if there are any further offenses in the future, they will have that record, and that's something that they will consider, and so will the Crown's office.
Can you talk who was held or bail?
Yes. So at the bail stage, there are three essentially tiers or considerations. There's primary considerations, whether the person's a flight risk; secondary, whether there's a substantial likelihood of reoffending or interference with the criminal justice system, which includes the public safety assessment; and then the tertiary grounds, which is what the public's interest be, or rather the confidence be impacted by this person being released or not released. It's a very simplified way that I summarize that. Here, the concerns are on the secondary grounds, that there may be some further offenses, the victim may be, subject to more violence in the future. That's one concern. The second concern I would have is the primary ground, which is the flood risk aspect. Raja is these are here on a student. He's been here for 3 years, but on the flip side, he has children, he has a business to stay in campus. Those are the considerations I would kind of think of. If he was released on his own,
If he was not released, he was held for
okay. Yeah, that's a little bit, you won't really see that often anymore during COVID. Since the pandemic started, the police have been exercising their own discretion to release people on conditions on the side of the road, if you kind of want to say, or they'll take them to the station and release them on conditions.
That doesn't really have a place to live, right?
Yes, so if they are satisfied that he will not return to the address and he won't speak to the person that's involved, those sorts of concerns, if they're addressed from the police's perspective. Here he was held for bail, likely because they didn't know where he would go and there would be a chance that he would return. Sometimes clients of mine would say to the police that I don't care what conditions you put me on, I'm going to go back to the address. That will definitely keep you in jail. So it doesn't look like Roger said any of those things, but the police, for whatever reason, did not choose to exercise their discretion and kept this person in custody. If this was, it looks like he came home late in the evening, that means he would be in the hold-up cell until 9 a.m. the following morning until court opens, whether that's on a weekday or weekend. They would speak with duty counsel, they would speak with private counsel, there would be a bail hearing. Again, the concerns would be the primary and the secondary grounds, but he was subsequently released with conditions not to have contact with Renee or with the children except pursuant to a family court order. I would not impose those conditions on him. I would simply say, do not go anywhere near her, which would include her residence. I would not include a condition that he not speak to the children. I don't think that's fair. There was no violence alleged that was against the children. What I would allow is exceptions to the contact and exceptions to the radius boundaries to allow them to have contact for the purposes of the care and access to the children, for medical emergencies involving the children, through a third party who is mutually agreed upon, so that, let's say there is a friend that they both trust that they can allow the children to, essentially be facilitated through that third person. And I would do through legal counsel as well. And that would include family legal counsel or criminal legal counsel or anyone that's representing that individual.
Thank you so much. So we have the high-priced defense lawyer who appears on all kinds of TV programs and things like that. She gets the call, and she gets the call from a friend who she has represented in the past. She's a good lawyer. She gets the call initially for bail. Michelle.
Good morning, everyone. I want to take this opportunity to talk a little bit about what I would do if I received the call for bail. Generally speaking, I would not receive the call from Raja. I would receive the call from a family member. They would tell me that Raja has been arrested by the police and that he is in custody. To the extent that it's possible, I would find out what police division Raja was at, and I would contact that police division and try and speak to Raja. I would then complete a standard intake form, and I would try and get as much information as I could about Raja and his background. I obviously would ask Raja if this was a situation where I thought a surety would be required. I would ask Raja if he has anyone in the community who could attend court to sign bail for him. But to be honest, given the facts of this particular case, I would make a submission to the court that Raja could be released on his own recognizance that a surety would not be required on the facts of this particular case. And I would recognize that even though Raja likely would want to have contact with Ronnie, and here it's abundantly clear that Ronnie wants to have contact with Raja, the court is going to order a condition that he not have contact with Ronnie directly or indirectly. I would try and get as many exceptions as I could to that standard no contact provision. As Rashmi indicated, I would ask for an exception. In this particular case, there was only one exception ordered by the court, except pursuant to an order of the family court, presumably because there's 2 young children involved. I would ask for more exceptions. I would ask for an exception except through a mutually agreed upon third party, again, as my friend just mentioned, so that way a family member or a friend could facilitate Raja's access to his 2 young children while this matter was before the court. I would also ask for an exception for legal counsel. The court would likely order conditions that Raja obviously not possess any weapon as defined by the criminal code. That is a standard condition that would be put in place. There would be conditions that he not attend at the matrimonial home, and often that he not attend within 500 meters of the matrimonial home. I would again ask for the same exceptions that I alluded to earlier. And I would explain to Raja, when he is released from custody, that he has to comply with these conditions to a T. And if he doesn't, he's at risk of being charged with failing to comply with a recognizance, which is a charge that's taken very seriously, that would result in him being charged again with another offense, brought back before the courts, and then he would be held for bail, and this time he would likely have to get a surety to come and sign bail to secure his release. I would tell him, even if Ronnie contacts him, that doesn't mean that he can speak to her. If Ronnie calls him, he has to hang up. Ronnie is not subject to any conditions. Raja is, and if he doesn't comply with those conditions, he can be arrested. So what Raja will inevitably say to me is, my wife wants to withdraw the charges. And Raja will think that that is going to be determinative of his criminal case. And I'll say, Raja, your wife does not have the ability to withdraw the criminal charges. She did not charge you. The police have charged you. And there's a metaphor I often use when clients say this, and they say this to me with regular frequency. What I say is, I'm sorry, the horse has left the barn. She does not have the power now to withdraw these criminal charges against you. In fact, in jurisdictions like Peel, police will often take video statements from complainants, recognizing that they recant with such frequency that they will take the statement from the complainant and they will record it. And that, I suspect they do that to try and prevent complainants from constantly trying to retract or recant allegations of domestic violence. I will explain to Raja that it's the police who lay charges if they have reasonable grounds to believe that an offense is committed. Now here, Ronnie contacted 911 and she reported allegations including assault with a weapon to win a slipper. That she said that Raja tried or threatened to kill her and that Raja assaulted her. I'm going to assume that she called 911, and so this 911 call is recorded. And then I'm going to assume she went to the division and they took a video statement from Ronnie. And so now I'll explain to Raja that it's now up to the Crown to determine whether or not they're going to prosecute this case. It is not up to Ronnie. Inevitably, Raja will say to me, well, what if Ronnie swears an affidavit saying that this never happened? And my response will be, well, that's not going to necessarily result in the charges being withdrawn either. In fact, if it were a bright Crown attorney, if it were Rashmi, she's going to ask the officer in charge to investigate the affidavit. And if it emerges that Raja tried to influence Ronnie to swear a false affidavit, he can then be charged with a further criminal offense of interference with the administration of justice. So this affidavit is not going to solve all his problems either. Then Raja will say, well, what if Ronnie doesn't show up to court? What if she doesn't show up on the trial date? What I'll say to Raja, well, Ronnie is going to be subpoenaed. A subpoena is a court order, and if she chooses to ignore it, the Crown, Ms. Kumar, has the ability to apply before a judge for what's called a material witness warrant. And if she doesn't come to court voluntarily, then unfortunately, if a material witness warrant is issued, she will be brought to court involuntarily, and she can actually be taken into custody. Because Ronnie has 2 small children, Children's Aid is going to be notified about the allegations, and they're going to know where to locate Ronnie. Obviously, Ronnie's whereabouts will be known because she has 2 young children. So there's no way for Raja to try and thwart the criminal justice system in the hopes that this will all go away. What I'll explain to him is what I can do and what I can do lawfully is try and negotiate with the Crown on his behalf and see if the Crown would be amenable to a peace bond or a withdrawal if he completes upfront counseling. But what concerns me about this fact pattern is Ms. Kumar may say to me, Ms. Joel, I would be amenable to a peace bond under normal circumstances, but there's an allegation that there was a child present. So the Crown Policy Manual has tied my hands here. I'm not able to agree to a peace bond. And then it may be that the Crown extends an offer of a plea in exchange for a conditional discharge and probation. I would explain to Raja that he needs to hire Damarkasu and get immigration advice because he is not a Canadian citizen. And if he wants to enter a plea of guilt, there may be immigration ramifications. So I'll make a referral to Daman so I can protect myself and paper my file, and he can get advice about whether or not that would result in a finding of inadmissibility before the immigration authorities. Perhaps I could let Daman speak to that. But ultimately, that's the advice that I would provide to Raja in a nutshell.
Justice Ray, so they come before you in a judicial pretrial, and you hear about the immigration consequences, you hear the children were present, alcohol was present. What would be your take on this, and what would be your position with respect to all of this? And we're going to get to Justice Kamani with respect to family law issues eventually.
What I do during a judicial pretrial, the discretion to make decisions at that stage really lies primarily with the Crown. And some of that discretion lies with defense counsel in terms of options and strategies, and ultimately an accused person has to make their own decisions. My role during a judicial pretrial is to simply provide some judicial reflection. One of the things I do, the first thing I do is he's in custody. And looking at this fact situation, I find it very unusual even before COVID and the pandemic that Raja is still in custody. If by the time there's a judicial pretrial, he's still in custody. And my take on the law, which I can explain during the JPT, is he's being released at the station. He doesn't have a criminal record. And I appreciate there's some aggravating factors here that would be taken into account when we reach the stage of resolving a matter or after a trial or sentencing. But at this stage, the principle that has to apply is restraint. And the police have been given a lot of discretion to release people. But there's a culture of risk aversion in the system among the police and among Crown attorneys who are not like Rashmi. And I think the culture of risk aversion in Toronto is stronger. The prosecutors also have a no-drop policy once they've decided to go ahead with a trial. And a victim can beg and plead and everything else that she doesn't want to go to trial. And they've been instructed, the Toronto Crown, is not to drop any charges. And I discovered that recently because of some media coverage. I didn't know what the Crown policy was. I noticed in court during a lot of trials that charges, if the Crown knew all of that beforehand, should probably have been withdrawn. And I had a suspicion that there was some sort of a policy that they wouldn't preventing them from dropping charges. I've read quite a bit of literature in the United States about no-drop policies. And the reason why I'm mentioning it when I'm supposed to be talking about judicial pre-trials is that's a reflection of the risk aversion in the system. So the first thing I deal with during a judicial pre-trial is, if he's in custody, I deal with that issue and I provide some judicial reflection. And whatever someone's done, and whatever the aggravating factors would be if the matter ever came to sentencing, and whatever aggravating factors the Crown has to consider in exercising discretion, at this stage, restraint is the principle. It's also relevant if the individual comes from a vulnerable population. And that is based on new amendments to the Criminal Code. The primary vulnerable population is the Aboriginal population. And then under the definition of vulnerable population, the blacks have been recognized by judicial decisions as falling within that definition. And Chinese also in constitutional law cases fall within that definition. You might be interested in whether Indian people and whether West Indian people and whether Guyanese fall within the definition of vulnerable population. What I'll tell you is there's no conclusive answer on that yet. But what I've read in empirical studies is that our populations tend to be arrested less than within white populations, that there tends to be less violence inflicted on us than not only black populations but also white populations. That's what the empirical studies that I've read conducted by the Ontario Human Rights Commission and other empiricists that have been hired by organizations. So we're perhaps not a vulnerable population, which would mean in these circumstances, one of the factors that would mitigate against being incarcerated prior to trial might not work for us. But that's an area of study among empiricists and an area of law among jurists that's developing. And there's no final answer to it. And so that's the first thing I would canvass, and I would do my best to, in this fact situation, persuade the Crown to agree to release, because if he hasn't had his bail hearing, I would push them very hard to have it, but there's been more than enough time to have one by the time we get to a judicial retrial. If we're at a judicial retrial and the person was somehow detained, and then I would push the Crown very hard for a release. And we can always put conditions in the release to protect the complainant and to make sure that the public is safe. This doesn't seem like a dangerous situation in general. And there needs to be some discussion about it just to make sure that the complainant is safe. There's no interference with her conditions of release. It's not a case where a surety should be required, and I would insist on that. Although it seems as if there seems to be, it's hard to tell from what's written down here, but it seems to me that there may be sureties available. But just because one's available, you don't have to use it. You're supposed to use the least possible interference with an individual's freedom that is consistent with the protection of the victim and protection of society. So I would canvass this bail issue because it jumps out at me and it's unusual. And so after the bail issue, I would canvass, since it's a first offense, and since there seems to be a going relationship here. This isn't a relationship that has fallen apart. This is a relationship where there's been unusual stress. And I would canvass resolution, and of course the Crown would use all of the points that Ms. Kumar has canvassed in her presentation. And I must say that she's restrained compared to what I want to do. And that might be a difference in the regions where we work. And it's really up to them, ultimately, whether a matter is sent to the Intimate Violence Court for a resolution and or some other form of resolution. And each judicial pretrial is unique and separate, and it's hard to generalize what happens to all of them. But we just provide some judicial reflection, and we try in these circumstances to avoid prosecution, and for the wrong reasons. Not because there's anything wrong with prosecution, but because there's a huge backlog of cases in the system. It's very expensive to prosecute, and there's really financial motivation behind it. I hope that answers the question.
It answers that part of it, yes. So, Justice Reddy, the Crown is playing hardball, and they are insisting on a plea. And they're insisting on a plea to either the weapons charge or the threatening charge, which would attract immigration consequences. And you hear the defense lawyer making the pitch. What is a judge likely to do in these circumstances? Would they impose a conviction? Will they give a discharge? And what's the factors that come into play in making that decision?
Are you talking about once we get to court or at the judicial pretrial?
At the plea stage.
At the plea stage. Okay, very well. There are as many different approaches to that as there are judges. I can only tell you what I would do without prejudice to anything I might do if you end up in my court. What I'm saying here isn't a promise, it's just a reflection. And basically, first of all, for us, for most of us, I think, the emphasis is on procedure rather than the result. So I would say that I'm a letter from an immigration lawyer, and very often they can't afford to get these letters. So there are some other options that can be pursued so that we can get some kind of an opinion. Because we are not immigration lawyers, most of us, in the criminal justice system. And I'm not going to rely on one case or a lawyer to read another case. I want an opinion about this case. So I want proper opinion from a proper immigration lawyer, and there are some unusual ones like Professor Kassoum, who practiced both criminal law and immigration law, and they're also scholars in the institutions. An opinion from somebody like a lot of weight, there are some others people out there. And we get to know who the people are, whose opinions that we can rely on. And if it's someone we don't know, we look at the credentials and we make an assessment. And we consider what's said in the letter. But my role is more to make sure that correct procedure is followed, that correct weight is applied to the evidence that's presented before me. Depending on all of the unique factors in the case, I would give some judicial reflection. I might tell the Crown I don't agree. I might tell counsel some ideas of certain options when we have a very, very experienced one, like Ms. Jo Ayala. I don't really have to say much, but we have some with less experience. I have to give them some ideas about what they could try. And really, it's ultimately up to the judge if the Crown won't back off. And I find, because I've been around for a long time and I have good relationships, and people seem to respect me, that often they do listen. So it's not a useless exercise, but I can't order them to back off and force them to. One of the options is just to go in under. You don't have to have a joint submission. I often asking myself, what's happened to advocacy? People don't want to go into court and advocate for their position. I think it's.
Can you explain the logic of an open submission?
Yes, an open submission is when the lawyers aren't making a recommendation that they both agree to the court. And an open submission is the Crown says, I want 10 years of imprisonment, and the defense says, I want a conditional discharge. Well, that's a rather extreme version of it, but they both explain why, and then the judge decides. And so there is some risk in going ahead with an open decision. Sometimes you don't know which judge you're going to get. Sometimes there's a surprise in court, and you don't know in advance what the sentence is going to be, and you can't reassure your client. And in this case, it would be very important that he didn't get a conviction or a criminal record. And so there is a risk. But I like to encourage lawyers to have confidence in their advocacy. That's why they're being hired, and to believe in themselves that they will get a good result for their clients. And if all else fails and he gets a conviction, I won't get into what the options are after that. But this is the Vishnu Mandir, and we're spiritual people here, and we have ways of looking at these things. Sometimes it works out.
I know there's a question. We'll hold the questions to the end. Any other comments, Justice Reed?
I have a lot of them.
Yes.
I'll save them for another time.
Okay. Justice Kimani, I'll make a further twist to the fact pattern.
Why not?
Yes, the husband and wife, they're now fighting. And custody and access are issues. It's all in your court.
I had a feeling that was going to happen.
Yes. I don't think you need it. Something happened to me when I became a judge. My voice was just fine when I was a lawyer. I think it has something to do with the fact that you're sitting down. No one can hear me in court. I don't think you have that.
Well, speaking through layers of plexiglass for the last couple of years has certainly taught me to allocate. Before Professor Kassoum alerted me to the loop that he just did, I can tell you that the fact scenario highlights two areas of family law, two distinct areas of family law. So let's start with one side of the brain, which is the child welfare piece. The child welfare piece is quasi-criminal. A lot of what you've heard from our esteemed panel so far directly transferable. Okay? The Child, Youth, and Family Services Act is what governs children's aid societies in our province. Similar to the bail analogy you've heard, where the requirement is a spectrum of intrusion. A society only intervenes if there are reasonable and probable grounds to believe there is a child in need of protection pursuant to specific and inundated grounds. It's a high threshold, and it should be. It's the state, and it's your family. That being said, in the fact scenario that you have, CAS has been contacted. It's required the children be present. And from my review of the facts, I've got a 2-year-old and a 2-month-old here. Teeny tiny humans. One of whom was being held by mom. That's a difference too. I want you to think about this. In my court, the kids are the focus. I refer to them as mom and dad. I'm not even going to call them Raja and Rani. And I get their permission in court before I do that. It helps situate me too. Because then who's center? The 2-year-old and the 2-month-old. I don't even know their names, but they're the most important people in me. So, getting back to the CAS piece of it, let's make the most efficient use of your learning right now. In the fact scenario I have, given at the time the referral was made, where mom was wanting involvement of dad, wanting to pursue perhaps request the charges be withdrawn, all of that is information that would be going into the Children's Aid Society records. All of that would form part of their investigation. On the facts here, with father outside of the home, the society would, more likelihood than not, close their file after initial investigation, likely refers the family to resources, knowing that father is currently not in a caregiving capacity, given he's not in the home. And they would say, give me the community supports, we're not continuing. Perhaps that's another educational opportunity that you can request going forward for a discussion about children's aid advocacy and intervention, etc. Shifting gears to what is likely to happen, it's going to go to family court, the domestic court. Let's leave the CAS piece aside. They're not getting involved, they've made the referral, they've closed the file, okay? Somebody's going to try and get it into family court, and they should. Because right now, 2 small children, no decision-making authority by anybody, no parenting time, and somebody raised the issue of finances. Let's assume that dad was the sole breadwinner. Okay? So, either it's going to come to my attention as an urgent motion on Friday at 4:30, and in all probability, anybody that's worked in the courts, and I'm looking at 2 very particular people who are nodding vehemently, given their commitment to 47 Shepherd. Would I grant an urgent motion in these circumstances on a without notice basis? Absolutely not. Not on a without notice basis. I wouldn't be inclined to do that because there's no urgency. He's not in the home. There's a condition that says contact through a valid family court order. That's why they're starting their proceeding. Okay, we've done it, we've started, we filed. You'll get in front of a judge soon. The only urgency here right now is parenting time and support. Those are the 2 issues I would consider. Decision-making, de facto, the kids are with mom. Remember that. So let's assume in the ordinary course they get into our court, and as Professor Kissoon indicated, mom's not so hot on dad anymore. She's like, wait a second. We're not agreeing with the way things are working out in our world. I don't want to extrapolate with respect to the event that is alleged to have transpired that resulted in a criminal charge. That's not my bailiwick, that's not my role. My role is pursuant to the Children's Law Reform Act, where I am to make an order, ultimately relating to the best interests of the children. Any order I make is taking into consideration the best interests of the children. When both parties attended my courtroom, I've got a he said, I've got a she said. And I'm using those gender pronouns because of the pronouns that I've been given in my fact scenario. I have 2 diametrically opposed versions. That's just Monday in my court. And unfortunately, there's very little I can do at that stage and in those circumstances. Because what I really need to know to make an order about best interests is, what time do the kids get up in the morning? Are they cranky before bed? Does anybody have any allergies or special needs? How are we going to try and stabilize the lives of these 2 children whose world was just turned upside down when the police came? One of them might have seen daddy hit mommy. Then they had to talk to grown-ups and strangers to say we're scared or we're not scared. Oh, and now daddy doesn't live here anymore and mommy's sad all the time. Not a stretch. It's about the kids. So as a lawyer advocating for this family, on either side of my room, I say, make your pleadings child-focused, please. No, you don't. I accept that parties are going to say this happened or this didn't happen. That's a bit of it. But how does it relate to the best interests of the kids? Here's my plan for parenting time. Here's my plan for providing support. There's an argument here that dad's got some difficulty with employment. I'm sorry, minimum wage in Ontario? You're going to be hard pressed for me not to impute that. For 2 kids, that's $469 or $492 a month right now. Okay? These aren't orders. I'm trying to make the maximum use of my time because I don't. How many of you do family law here? Out of curiosity. Okay. Then. So then the broad brushstrokes I'm giving you are sufficient. It's not for the faint of heart, family. It's complex. It's nuanced. But it's a privilege to do it. Let me tell you. It's prospective. They deal with the past, whether or not something happened. I get to help families. So, I like the pursuance of a family court order. I really do. Because it's my job to figure out best interests. I understand there may be circumstances where the Crown would want a specific exception with respect to the complainant, absolutely. But then, please don't make it overly restrictive from my perspective. You got to do what you got to do. It's a different domain. I got a different role. You got a different role, different pieces of legislation. We have different silos. But the silos do have permeable membranes as well. All right? I don't know if that's 15 or 20 minutes I talked. With pleasure.
Yes, well, criminal judges know that family judges are looking at the big picture and trying to put us a little in these orders, these no contact orders, as possible to give you the most discretion to design the big picture. And we worry a lot about the children and we can't help during the process.
I just want to say one more thing. If you are interested in pursuing child welfare or family law, the best thing to do is go and sit and observe in an OCG courtroom. It's the People's Court. Okay? You've got 47 Shepherd, you've got 311 Jarvis. Come up to Brampton. Go and observe. It's a fantastic area of law.
You're jumping.
Oh, am I? Okay. Oh.
We get into the legal education.
See, this applied to family. I can't stay in a straight line. That's kind of all I have right now.
Let's talk briefly about the decision. I will talk about let's talk briefly about custody.
Mike, please.
The custody aspect of the case. I know you talked briefly about it. Can you expand on that a little bit?
Absolutely. So custody is no longer the case. Custody suggests somebody is, for me, institutionalized. The legislation seemed to think so as well. There were amendments made to the Children's Law Reform Act. It's called decision making because when we're talking about kids, that's what we're doing. They're not a thing. They're humans. So custody relates to decision making. There are 2 aspects, there's several aspects of decision making. There's the urgent decision making, then there's the non-urgent decision making. Then there's issues related to travel and passport authority and these types of things. So when we're talking about custody at the first court appearance, a lawyer would likely suggest, and I would likely impress upon the other side, Dad, listen, in the circumstances of this case, 2 littles, they're going to need decisions made. Decisions like daycare, decisions like healthcare, decisions like a prescription, these kinds of things. Currently, there's a no contact order between the 2 of you. I'm going to assume that. I would likely say an interim without prejudice order for decision making in mom's favor is in the best interest of the children because someone's got to be able to make decisions about the kids. And I would likely suggest a duty on the mother to inform the father once the decision has been made on an interim without prejudice basis. Meaning, if and when dad's circumstances change, you can come back to court to say, okay, can we look at that now? Plus I've done these parenting courses you told me to do. Plus I've done all of this. I've improved my communication skills. Maybe we can consider a more collaborative collaborative decision-making model for the children. So custody relates to decision-making, parenting time relates to where the kids will be physically, under whose roof they're going to be sleeping, which house's pillow they're going to put their head on. That's parenting time. Okay? So that's the distinction, if I've answered your question, Professor Kassoun.
Yes, you did. This was an excellent presentation from the 4 panel members. Before we move on to the questions, and I know there's some questions, is there anything anyone of the panel members would like to add upon reflection?
So just very quickly about Ronnie's input and the fact that, she's telling the police she doesn't want to proceed with the charges, and she's telling the Crown's office as well. Chances are she would get a worker assigned from the Victim Witness Assistance Program, given it's an IPV domestic case. The proper channel would be for her to communicate to the Crown's office through that worker. The Crown is required to take the victim. Even though there's no conviction at this point, they're still considered victims under the Victim Bill of Rights. But the Crown is required to take their input into consideration, whether it's at the early stages, at the bail stage, or at the sentencing stage. It's just not determinative of what the Crown is going to do. At the end of the day, the prosecution is the Crown's, and so the discretion is solely held by the Crown to determine what is going to be the end result. That with the stipulation that, of course, if it's going to be a plea and it's not really the Crown's decision, then it's Justice Ray's decision to decide what that plea is going to be, what that sentence rather is going to look like.
I also have one thing that I want to add. I talked about options for Raja. I talked about the Crown potentially withdrawing the charge and a peace bond resolution. I talked about a potential plea where I would seek a discharge. I forgot to talk about the most important other option, which is a trial. So Raja could put the Crown to their onus of proving the case beyond a reasonable doubt. And if the Crown will not withdraw the charge at an early stage, he doesn't have to plead. In fact, what I would recommend is that we schedule the matter for trial. Only downside is the courts are very backlogged at the moment. They were backlogged before COVID, and COVID has only exacerbated that pre-existing backlog. So unfortunately, Raja will not be able to get a trial tomorrow or next week, and it could take up to a year. But that certainly is an option that's available to him, and if the Crown would not withdraw, that would be the option that I would recommend to him. But it's a long process.
Oftentimes, Doc, we're coming to you in a minute. Oftentimes, the threat of a trial makes the Crown see the light of day. Because the backlog is quite substantial, and there are bigger fishes to fry, so to speak. So, while we'll be going to questions now, is this a good chance for? It's 5 after. Okay. So while we'll be entertaining questions, we will not be entertaining very specific questions with respect to something that's ongoing in the courts. The judges and the Crown Attorney and the lawyer cannot answer those questions.
What I was asked to discuss, I can assure you, when a family is in my court with a scenario as common as this is, when I speak about parenting courses, when I speak about the fact that the children were exposed to a tremendous change regardless of how or why it happened, that gets built into a parenting plan. Therapeutic intervention, therapeutic support. Because what we cannot afford is for it to happen as a pattern. Again, we try and disrupt that. So perhaps, as Dr. Kassoun, or Professor Kassoun indicated, it is fodder for, I think, a broader conversation. But rest assured, and I'm not unique, the Ontario Court of Justice family court judges that I know, this is something that is considered and implemented in ordinary course.
May I add to that as well? So specifically at the Newmarket Crown's Attorney's Office, or the courthouse rather, our jurisdiction goes from Markham all the way to Thornhill, essentially just shy of where Barrie and the Barrie-Simcoe region begins. We have something that's called the Domestic Violence Community Treatment Court. So accused persons who have concurrent disorders, psychiatric disorders, substance abuse disorders, depending on risk assessments or the Crown's analysis, we may offer them admission into that treatment program. They have workers with the Canadian Association of Mental Health, with the Addiction Services of Central Ontario. There's caseworkers, and essentially the focus would be to getting that person assistance with their disorders and their whatever struggles that they're dealing with. Chances are, after successful completion of that program, it's such a diversion, so the charges are withdrawn or there's a peace bond, but it's more of an intensive intervention to assist with those people who have those psychiatric needs.
In criminal law, the mental health is an issue that is offender-focused rather than victim-focused. And in this type of fact scenario, if it eventually gets to family court, that's where those issues are dealt with.
There was a question in the...
Representing Craftsman Center here with my colleague Linda, and I'm the team lead for the Richmond Hill Drop-In Center, which is located right near Yonge and Major Mac. It's not too far from here. And we see a lot of individuals who travel to Toronto, travel to Newmarket, travel along the Blue Line. And what I want to say is this topic today really is close to me because I've been that kid who's witnessed domestic violence, whether it was my mother, whether it was my aunt, whether it was my other aunt. And I'm in a better place right now. And I have to give thanks to God for that, and also just the support that I've gotten from all the women in my life throughout my entire life. They've really been the stronghold, the breadwinners, the supporters, the empathetic listeners, and it's made me the man that I am today. So I really thank everyone for bringing this topic to discussion because it can't be taboo. It does happen. And the more we're able to talk about it, the more we're able to connect with each other and find the solutions that we need for ourselves. And my question is, we've talked about sort of what the steps are when things get to the justice portion, but what supports are available for our communities prior to that, where they can engage with other individuals who may be going through similar circumstances and gain support from one another if they don't want to seek legal support or take legal action. So that's my question.
Yes.
So, as I mentioned earlier, our community, our temple, has put together the Domestic Abuse Initiative, Domestic Violence Initiative. We started that in 2011. It has had so many hurdles from the community. As a matter of fact, when we held our first meeting, I was followed around this temple by people who just didn't want to listen and hear anything about domestic abuse. It's a very, very, very hard topic to approach. We've been struggling to get into the community, but we've never ceased trying. We're working right now, I'm in talks with CAMH to get CAMH involved. They've been holding up our dates, so I'm going to speak to you, Professor, afterwards, to put together a session specifically on mental health. And we're trying to work with Craftsman Center as well to provide support to families who've experienced mental health issues and domestic abuse issues. We've worked, as I said, we have a partnership to put children and spouses in safe homes if there is domestic violence, but nobody wants to come forward. But we continue and we're working, and I am the face of domestic abuse for this organization, and I'll continue to push forward to get help for community and education. So it's not an easy task and it's a continuing task, but we will do it. We have another question here.
Absolutely.
Good morning, everyone. I am coming from the probation angle. My name is Chandra Sukhdev Singh. I'm the court liaison officer. When I'm reviewing charges where clients have failed to attend counseling as directed at court, one of the situations that come up all the time, and it seems to be a gray area, and I'm so happy to be able to speak directly to Your Honor. Sorry, I'm directing this question to any of Your Honor. Most times when we have the problems, there's a condition where a client is directed to attend counseling as directed by the probation officer. In the case of the DV client, we come across issues where the client says, hey, the judge never told me I had to attend PARC, and I'm so glad you brought up the PARC program. And this is a situation where some of us are having issues because if it is not clear on the order, then the client could go to his lawyer and say, hey, the judge did not say this. My question is, what determines whether a judge puts attend for PARC as opposed to attend for counseling as directed? Because that makes a big difference. The ministry has a policy of once a client is identified as DP, they must attend the PARC program. However, the court speaks another language. So can you...
That is a wonderful question. Put the judge in the hot seat.
All right, very well. Can you hear me? Yeah. All right, very well. The law is, whether you like it or not, that the judge is supposed to make the decision. And I take the view that I cannot make that decision without any information. And crowds that are in a big rush come into court and ask us to order attend counseling as directed by probation services. And I think that's an illegal condition. I think that we're delegating our discretion. There's a principle we learn about in law school that discretion cannot be delegated absolutely. There have to be some criteria, there have to be some boundaries. That's the law. So I always ask for more information about what's the problem, what kind of program is it, and is there a specific program in this context, like PARS? And usually when I probe a bit, they'll say, well, PARS, of course. Well, why didn't you say that? So usually we put PARS into the order unless something else very fact-specific to that situation is more appropriate. Sometimes there's a special program, culturally based program. Sometimes someone has a mental issue, and within the context of that, another type of program is appropriate. And we make them explain things to us. Domestic abuse counseling is a bit different from anger management counseling. It's quite different from anger. So that all has to be explained so we can make a decision. And counsel have to do their job and make really good submissions and do their research and not just parrot the ground, oh, any kind of counseling that the probation thinks. And if we need more information from probation services, we have the discretion to ask for it. So sometimes my sentencing hearings take a bit long. They take a long time because I want to do the job properly, according to legal principles. And whether or not it's what people like judges to do. That's what I do because I believe in the rule of law and I'm governed by law and follow the principles and explain it all in my decisions. And any third party reviewer can look at it and decide whether it's wrong or right. But I don't just leave it up to probation because I think that's contrary to law. If you all feel that that's not what judges should be doing and that judges should have the discretion to just say leave it up to probation services, you can write to your members of parliament to change the law, and if you change the law, I will follow it.
So, I know there's some other questions. Hold on. Michelle has to leave. Her kids are participating, I can announce it, right? Her kids are participating in a spelling bee competition. And they're in the finals, I heard. And she has to leave, and we have to say a special thank you for her to coming out on this rainy Saturday when she could have been doing a number of other things. Michelle, thank you very much. And if we ask you to come back in the future, will you come back?
I would be honored to come back. Thank you very much for this opportunity. Thank you to Professor Kassoum and my fellow colleagues.
And there's a little presentation, a little token, and Mahatma Gandhi made many famous speeches and sayings, and the token of Michelle, and the token of the appreciation is something from Mahatma Gandhi. Thank you so much. So we have another 10 minutes for questions. I know, Roy, you have a question. There's a young lady here and there's a man here. So Roy, hold on. The young lady first. The microphone.
In terms of situations where someone like Raja would have been wrongfully convicted, so like his wife made something that was false, how would you go about it as judges? So he wasn't actually, he was accused for no reason, just out of spite or out of anger from his wife. What would you guys do in those scenarios?
Okay, so that does not get to the judge at the earliest stages. The lawyer that he has retained will bring that to the Crown's attention, saying, whatever the reason, she may be using the family court issues, the criminal court to enforce family court issues. I will bring that to the Crown's attention, and the Crown oftentimes will consider that as a factor. It is not a determinative factor. If the Crown does not agree with our position, that's the defense, then we take it to trial. Madam Crown.
This happens often as well. So oftentimes if a defense lawyer comes to me and says, well look, the victim here is making this up, they're using this as pressure to get the kids or to get money, of course I would consider it. If it's a matter that I cannot resolve with a withdrawal, then I would say let's just set it down for trial. Family court proceedings and what happens in family court can be used in criminal court, so the defense lawyer can use that to cross-examine the victim. And then at the end of the day, the kind of cards fall where they do, right? The standard to me, and Her Honor, Justice Gray will tell you this as well, is I have to prove the charges beyond a reasonable doubt. That is an extremely high threshold. It needs to be almost certain that that person committed that offense for the judge to find that person guilty of that offense. And so I would say the chances more often than not, let's just set it down for trial, let's see what happens.
Roy has a question over here.
Sorry, Professor Kassoum, I
Yes.
just wanted to add a piece from the family. That's okay. Because ultimately, the issues with respect to parenting, they're determined by the credibility of each of the parents. And if it is found during the course of the family proceeding, either after trial or at some other point that the allegations were fabricated, that is something the court would take into consideration when it comes to ultimately the decisions around in whose
care would the children be in whose care is it in the best interest for the children to be in if one of the parents is found to be fabricating things about the other parent?
The victim does not show up, and the Crown has other evidence, and there's a guilty finding based on the other evidence, and then the victim shows up at sentencing because she wants to make it right. And she says, I made it all up, none of this happened, and the judge has the discretion to declare a mistrial and to stay the proceedings. And it's not a discretion that's exercised lightly. We have to hear all the circumstances. We have to decide if we believe her. We have to hear from the Crown. We have to hear from the defense, and a case-specific decision is made when that happens.
Thank you, Your Honor. According to the panel, Your Honors, this was a fantastic presentation. Thank you. So my question is whether there should be a domestic violence registry. So CBC ran a very brief segment last week where victims are reaching out to each other to help each other, and whether the question is for repeat offenders, just as we have a sex offender registry, whether there should be one created. So my question is, what are the implications and what are the likelihood that it could occur? And I guess an offshoot of this is that for young women in the dating community, they have started social media groups, Facebook groups, other social media groups to alert each other to dating partners that might have abusive tendencies. So on the one hand, while this is, it's commendable, from a lawyer's perspective, I also see concerns about defamation. So I just wanted to know, because we have multiple perspectives, what your thoughts are.
It's a wonderful topic. It is not likely to happen anytime soon. That's my view. I may be mistaken. But in the interest of time, there's another segment to this. If an aspect of law, we have probation, we have family counseling, we have the judges, we have the defense lawyer, we have an insurance defense lawyer, we have another insurance defense lawyer. The questions you may want to, what's the best way of proceeding with this? Questions or with presentations?
I think we should probably go first with the tips for getting into law school and other legal careers, and then leave it open to questions.
All right, so can we ask the two younger lawyers to what were their efforts in terms of getting into law school? And so, Rashmi.
So I'll start with undergrad. I did a 4-year bachelor's degree in criminology and psychology. I didn't really initially want to go into law school and become a lawyer, but my courses were very persuasive, and I essentially built that interest. I did an honors theory thesis in psychology, and I looked at what mock jurors, their considerations in sexual assault trials. So I considered how does the complainant's actions or the accused person's actions, how do they interact with what does a jury think essentially at the end of the day. I applied to law school, but before I did that, of course, I wrote the LSAT. I took a prep course, highly recommended, it was great. Scored decent, and then I thought maybe I'll try once more just to get a couple more scores that are higher. That worked out, and then I went to Queen's, and at Queen's I took a course with Professor Kassoon. I met Justice Ray. Education was fantastic. I did a clinic program there where I worked in the maximum security prisons in Kingston. So that was really cool. And then then once you finish law school, it's a matter of just getting a job and going through the remaining process. Specifically in terms of what you should be doing if you have an interest to go to law school is really show that interest. Do what you can so that when you apply to law school, when you apply to jobs, you tell your employers or the decision makers, look what I have done. This is how I can tangibly show you what my interest is, and and why I want to do or work with you or go to your school, whatever your goal is at that stage of your life.
Christine.
So my path, very similar to Rashmi's, but also a little divergent. I did a 4-year undergrad in criminology with a minor in sociology. I actually worked for Mr. Kissoon for a number of years, and I read through his material on his Queen's University criminal law syllabus. So I think that was a very good introduction to sort of the arena of law. But I did a master's, so I had a little bit of a detour, also in criminology, but you know, law school didn't happen right away. And I would kind of encourage everybody to be open to different pathways. The advice I would give is volunteer, and you could do anything. You don't need to do criminology. You could do an engineering degree and apply to law school. So the steps that Rashmi mentioned in terms of studying for your LSAT, applying, that's sort of its own component. But I would say that the volunteer experience is, it's very enriching because you can add that into your personal statement. And it does, I also volunteered at the ICU in a hospital. And this was sort of a segue thing as well, but it came up and I was able to relate a lot of my experiences to the kind of things that I wanted to do with my law degree.
I know Hera did some research yesterday, and
Yes, I've been out for quite a while, 31 years of practice and retired recently, but I can't overemphasize the importance of standing out. You stand out, unfortunately they don't know you personally. It's a system that is sent out to law schools, and based on the information, they can only act like the judge was saying, your Honor was saying, whatever is in front of them is what they can decide on. Same with the selection panel as well. If you want to be selected, you got to sell yourself. And I found my secret was having a very high GPA. I think that's why I got the scholarship award for having the highest GPA at Osgood, because you have to carefully select your courses, the school you intend to go to. You don't necessarily need a big brand school, and you don't have to have study political science. That I was told it's very boring. I know there are people who study that in economics, which is very enriching. Study something that you will enjoy and that you're good at, because they're looking at grades, they're looking at your LSAT, so take your prep courses. There could be rip-off artists out there offering prep courses, and make sure you're using a reliable and credible one. And as well, your personal statement, your volunteer experience, sell yourself. Start doing volunteering now. And with your GPA and your personal statement and your LSAT score. LSAT score is not necessarily the determinant factor in all law schools. Do your research, some of them lean heavily on the LSAT score as opposed to others. Some tips.
Justice Kennedy.
So I don't know that I should talk to you about this because I didn't like law school. I quit after my first year, true story. I'll tell you why, because I was trying to be like everybody else. And then I realized, I gotta do it like me. So I traveled and I worked. I went up north, I worked on the division of the territories with the government of the Northwest Territories. I traveled coast to coast, much to my South Asian parents' chagrin, by the way, because you don't quit law school. I did a lot of seva. I did a lot of charity work. As Mahatma Gandhi says, the best way to find yourself is to lose yourself in the service of others. And then I went back on my own terms and I found my niche. And I knew I wanted to practice after I did the legal aid clinic. That's how I found my way. So as you explore this chapter or this career, everything you've heard is super important, the grades, your LSAT, but none of that's gonna come if you're not actually passionate about it and if you're not yourself about it. So that's kind of what I have to add to this. And then you won't feel like you're working a day in your life, let me tell you. Justice Ray and I have really privileged lives in the sense of, I always say I have the best job in the world, I get to help people. So that's kind of where I come from. And I've never looked back since my graduation. Thank you.
It's been a very long time since I tried to get into law school, and nothing that I can say about it is going to be relevant to what you have to do if you're trying to get into law school. I did once arrange with Professor Kissoon for a former associate dean of a law school, who's now a judge, who was on a lot of admissions committees and who formulated the criteria for exceptions into Osgoode Hall Law School to come and talk to a group like this. And quite frankly, someone like that would have a lot more relevant things to tell you than myself. What I can tell you is that if I know you well, I could write a reference for you. I've yet to find a case where I think it really helped someone get in. I think what really helps you get into law school is your own merit.
So, one of the things in the meet and greet and the invitation that you have just been offered, take her upon it. She is very helpful. Rashmi will tell you that.
So after I completed my program with Professor Kissoon, Justice Ray and I had lunch, and it was great, and I shadowed her, and I learned a ton, and we have a great relationship. So definitely take advantage of opportunities that you have, build those connections. I wouldn't be in the CAMS office if it wasn't for Professor Kissoon, so a huge thank you to him always. So take advantage of that. What I will say also is mature students always get into law school as well. So if you decide to just go to college or go to university and start working, and you've been in the workforce for 5, 6, 7 years, maybe even more, apply to law school. That's okay. The admissions committee wants to see that you are a rounded person. They look at the applications usually holistically. They want to see what you are going to bring to their program.
What was the preparatory course you took for the LSAT? Was it Oxford or Kaplan's?
Neither. I had preferred, I'll keep my opinions to myself, but I found a little bit more of a smaller group. It was, if you guys are interested, I'll give you the name. I don't think he runs the program anymore. I think he had scored at the 99th percentile by the instructor, and I think now he's in law school and has become a lawyer, but he was brilliant, and it was a very good course to take.
She mentioned a little bit LSAT, we're using acronyms. It's a law school admission test, and it is not based on any specific area or subject area. It really tests your logical thinking, your analytical thinking, quick thinking. So the best way to do that is to prepare. Unfortunately, when I wrote mine in 1989, I was a new immigrant to this country, and I wasn't even aware of the services prep courses. And so I bought the books, and I used hard copy books and prepared. But preparation is key, so you're familiar with the testing. I wanted to make another point. This is my personal perspective, there are 28 law schools in Canada, 8 of which is in Ontario, and they're all good law schools. Don't be picky, apply to all of them. I applied across the country when I applied, and if you're forced to and you have to go abroad to study, I would strongly recommend that you come back and do an LLM, because to enter into the LLM program, the master's program in law, is a little bit easier than it is to do a bachelor, to get into the bachelor program to study law. So if you are from abroad and you do want to study in Canada, apart from the accreditation process, by which you can be certified to practice in Canada, you can also do an LLM, then you can have a master's of law given to you, granted by a Canadian law school. I think that looks good when we apply for jobs.
The same, I had books. I had a small prep course, which I found a little bit more easier because you have more one-on-one attention. And mine was called Jim Richardson. I don't think he's practicing anymore, but he also was assisting with personal statements, which the networking in terms of knowing how to go about doing that is also very important. So if you can't find it within the prep course itself, definitely ask questions when you're networking. There are a lot of people that are willing to help.
Is there anything to add from any of the panel members before we open it for questions?
The LLM course Washington Hall Law School. It's excellent, and so many foreign trained lawyers have taken it and become Canadian lawyers. When I graduated, there were a few hundred people in the class, and half of them were foreign trained lawyers who had done that program. I did an LLM that's for domestic lawyers. That's not for the foreign trained lawyers. It's not the common law LLM. It's the part-time LLM program for professionals, and they set it up so we can juggle it with full-time careers. And for any of you that are already lawyers, it's an excellent program. It was a very good experience for me. The only problem with it is that I don't answer questions quickly like I did when I was a peer practitioner, because there are all these factors that you take into account before you reach a decision.
So one of the things that you have not heard about Justice Ray, while she was a presiding judge, she completed her master's, and now she's working on her PhD.
One of the tricks as well, it's not fair, and I know the Ministry of the Attorney General has been rectifying the issue. I've been selecting people to become outgoing students for the government over the last 30 years, and as well as lawyers, young lawyers. And one of the things that baffle us is when we come in with foreign accreditation, we don't quite understand, and we make an effort to do so, to understand foreign grades. It is so much more familiar for us and easier for us to understand Canadian law schools because we've been through them. But when you study in Europe and you come back with even the US, the grading system is so different. So if you do go through the LLM and you come in with a Canadian master's, and maybe I should not be recorded saying this, I think the selection committee more favorably look at those applicants.
The selection committee finds it even more difficult to look at law degrees from Afghanistan, the Ukraine, and they're having to look at those nowadays, and they're really baffled.
One of the things that you've heard is about the personal statement. It is important because if two students are identical in grades and LSAT scores, and they have to make a decision, then the fallback item is the personal statement. Take your time and write it. If you need help, get the numbers from all these people here and reach out to them. They're not only here to make a presentation to you today, they are resource material for later on. Right? Nobody's saying no. So, please, Justice Ray has assisted Rashmi when she graduated, and she shadowed her and opened other doors for her. Rashmi was able to use that on her resume when she was applying to become a crown attorney. So all of these things add up at the end of the day. So if you have to make a call to someone and you say, well, Rashmi is a good candidate for your crown attorney's office, they'll ask you why. Well, she's a bright student, she was a student of my class, and she got an A, and she also got a paper prize. I'm telling them too many stories now. Anyhow, but apart from that, she's a good lawyer. And the crown attorney that I made the recommendation to listen, and she is in that office now. Look, we can open doors for people, but you have to be able to walk through. And when you walk through, you have to be able to stay there. And some of our people sometimes, even though we're opening the doors, anyhow.
It's primarily your own merit. It is primarily your own merit, and no one should feel bad because they need a little bit of help getting started. All those years ago when I started, what tipped the balance for me, because there were so many barriers, is that I did have people who helped, and somehow found people in the system who helped them. And then they're very happy later on. Do you know how much joy it gives me when I see where she do submissions on sentencing? She does them properly. I wonder where that influence comes from.
Only one time, and then after that, it didn't happen again.
And Justice Ray is also fluently bilingual. That is French, not
Well, I would like to back to our law program. If you apply medicine and don't get through medicine, apply to law.
Law is never a fallback position, Dr. Dubey.
If you don't kill them, you can defend them. We have medical clinic here, we have a other clinic here. We just focus on mental health. Or Dr. Farmer, go.
Right, so I'm currently a grade 12 student planning to attend university next year and then hopefully law school in the future. So I was wondering, how much does your undergrad play a factor when you try to apply into law school? And also, does it matter really what law school you go to? Let's say you go to Queens or U of T versus a lower ranking law school. How much of a factor does that play into getting your first place or your first job?
So, the undergraduate does not really matter. What matters is your grades. So, pick courses that you will do well in at undergraduate. But also don't waste the undergraduate by taking some artsy-fartsy course. Take something just in case you don't get into law school. You can use your undergraduate degree for something else. In terms of law schools, well, we have the two judges, they both went to Dalhousie. Fantastic. We have Osgoode Hall at the end, another fantastic law school. Ottawa U here, 2 Queen's graduate, the other lawyer that left is also a Queen's graduate. It doesn't matter which law school you go to. Go to the law school and distinguish yourself as a top student. You have a follow-up question. Anyone, any other response to his question?
No, there's no, as an employer, we really like looking at Canadian law degrees because we're not too familiar, as I said, with foreign schools. So any Canadian school, apply to all, and whichever you get in, study hard, you will succeed. It doesn't matter if there's no ranking in terms of hierarchy.
And then I have a follow-up. So I have a follow-up. I know that the LSAT, personal statement, your GPL matter. How much would you say extracurriculars and standing out matter in comparison to those other 3 factors?
A lot. A lot.
Because a former associate dean of Osgoode told me that they count a lot, but a former associate dean of the University of Toronto told me it's all marks, just marks. So depends on the law school.
I should take it one step further. I'm assuming you're going to, we're trying to get into law school. In my view, by doing the other stuff, you're enhancing your skills overall. And if you're enhancing your skills overall, that's going to reflect in your personal statement and ultimately in your law student career, which will ultimately get you to be a legal advocate that is a more fulsome, wholesome, overall good advocate. So I'm assuming it's not just getting into law school, but becoming a good advocate, which is why I say it matters a lot.
If you can't decide, do a language. One of my former summer students his parents came from Chile and he was fluent in Spanish and he had work experience in Chile. He used to do presentations on financial management and financial aspects of law in Spanish in Chile. And he got into a top Bay Street law firm and so many people wanted to be associates. And they picked him because they were building up their niche of Spanish clientele. And they wanted someone who could serve the clients in Spanish and understood their culture, how they think, how they would like to be served. So he got taken on after, well, he got articles and then he got taken on after articles as an associate. And I studied French because I love the French language and there's some history of attachment to the French language in my background that I won't go into. And it opened doors for me like you wouldn't believe, and I didn't expect it to. And so if you can't decide what to do a language.
I just want to add to that. So let's say you don't have the opportunity to volunteer. That's okay. If you worked at McDonald's for 4 years in order to get yourself through undergrad, tell the admissions committee that. Because what do you get from working for McDonald's? You get to work with difficult customers who are yelling in your face. You figure out conflict management. You figure out, there's so many skills that you can learn just working in a fast food restaurant that will actually, they can essentially be applied in law school and they can be applied in the workforce in the legal career as well. So don't cut yourself short. If you're able to volunteer, that's amazing, and you should have those opportunities that you have.
Shivani?
I just wanted to add that when I was
Microphone, please. So, by the way, Shivani is also a lawyer.
I just wanted to add that when I was an undergrad, I would always reach out to professors and I would say if there's anything I could be involved in. I was kind of confused when I first started undergrad, and so I got into a lot of research programs because of that, and there were paid research opportunities. And these were the professors that eventually wrote my reference letters for law school, and I think that was a huge factor in how I got in. So you can always look at that avenue when you're looking about what to do for extracurricular work.
I would just add that outside of the extracurricular work, just take on interests and hobbies, because later on in your career, you might need to talk to people and network. And I can tell you that when Toronto has an article in Recruit, it's run over several days. And these corporate firms take place, insurance defense firms, you're meeting all kinds of people from different backgrounds, different ages, and you need to connect with them in a very short period of time. So I found an easy way to do that was with art. It could be anything, it could be gaming, it could be something else, but if you know it's sufficient enough to have a conversation and to have an interest, you can pursue that and relay that to your advantage.
As you mentioned in terms of, I know we have young people in the audience, but in terms of getting into school as a mature student, that was mentioned here as well. I had a situation with one of my colleagues who graduated from law school. He went in as a mature student. He was a manager of a fast food restaurant, but he was able to convince the panel. Not only had he had the management experience, the ability to think, etc., but you have the leeway as a mature student to add other things in terms of extracurriculars. He won the Ironman race. So, I mean, you don't have to be the greatest athlete that he was, but anything such as athletics endeavors and so on could also be used in your personal statement, whether as a mature student or first time, a young person applying to law school.
If you'd like to talk to me individually about the differences between or among Dalhousie, Osgoode, and Queens, I can tell you because I've been a student at all three places and I've taught at all three places, so if you're interested. They are all three excellent law schools, but there are differences.
Any other questions? Yes.
Yeah, so first I would like to thank you guys for the presentation. It was really informative. Yeah, so my question is that I'm finishing my Master's of Science. So I was wondering, like, for my personal statement, yeah, for context, so my undergrad was also in science. So I was wondering how I would kind of like convince the panel that like my research skills, like knowledge in science, would make me a good candidate for law school.
Science is a fantastic background for law school, and we can talk about that afterwards if you like.
I went to the swearing-in of a young judge in Brampton, and she was an engineering student in her undergrad and her master's. And the statement she made, you all didn't expect me here, expect someone like me. She was also Chinese, and she was making an interesting statement. You did not expect someone like me to be sworn in as a judge. She was coupling with the fact that she was Chinese, but she also meant to say that an engineering student becoming a student of law and then becoming a judge. Very bright woman. So if your grades are good, they will look at it irrespective of wherever you're coming from. That's my recommendation. Apply. There's a question here first and then one at the back. Yes.
Thank you, dear panelists. My name is Henry Gasper. I've heard among some of my friend groups, people who are deciding to go overseas to do foreign law degrees and then come back and practice here. For those who might be thinking about taking that option, what advice might you give them if they choose to return to Canada and pursue a legal career here?
The advantage of pursuing a foreign degree is in some countries you can go into law right after high school. The disadvantage is when you get back, it's very difficult to get your Canadian accreditation. So those are the things that you have to balance. And your references, people won't know them. Depending on where you go, there are some places you could go and they would know them. And
Sorry, HERA did address that. When you come back here, you can go on to do a master's, or you can write the NCA exams. Generally, young people who go overseas, it's an opportunity for them to get away from their parents. Seriously.
The parents pay for it.
Yes, and they go and they party, and they come back with lower grades, and nobody respects low grades. So the people who are going overseas, the encouragement I give them, go there, have a good time, but make sure you study and come back with good grades, minimum a 2-1 or a first-class degree. If you come back with less, nobody looks at it. Anything else to add?
So it may be easier to get in, but staying in law school can be more difficult, especially in London or in the UK if you're going there. Number one. Number two, when you do come back, if you're going through the NCA process, you're going to have to write several exams. If you just decide to do the LLM, then it's an easier process. You don't have to write as many accreditation exams, which is really good. But I think the most challenging part of being a foreign trained lawyer, even if you're going to be studying in a Commonwealth country, is that when you come back, the law is still different. And so there may be some difficulty when you're doing your bar exam. So I agree the LLM program would be a better route. I have family members who were foreign trained, did their LLM, and now they're working at one of the Seven Sisters downtown. So it's not impossible, you just have to grind and do well.
You can always do it the other way around. A 1-year LLM takes less time and is less expensive than a longer LLB or JD program. And wonderful people have their LLMs from the London School of Economics and Indian leaders over the years did their, not LLMs, but graduate work at London School of Economics. Indira Gandhi, Benazir Bhutto also went there.
There's a question at the back.
My name is Anne Kuhn. And yeah, just a quick, simple question. How does the salary scale for a young person finishing law school and entering their first job, you Mr. Davin soon, how does it relate to the school, the law school that this person may have gone to?
It doesn't matter. It does not matter which law school you come from. It depends upon where you end up. Obviously, if you end up on Bay Street, you're likely to be paid more than if you're on Main Street.
Because my sort of feeling and understanding with my daughters and different, it's all, and not only law school, different, that it matters a lot what university you went to. The salary scale starting off is very different.
Your information is different from mine, and I've been doing this for 30 odd years.
Thank you.
You have to become a lawyer for the right reasons. You become a lawyer because you have a passion for the law, and you want to make a difference. And you care about justice if you want to do criminal law. If you're becoming a lawyer for financial reasons, choose something else.
I have to endorse that because when I got my first job and I saw my first paycheck, I went immediately to my manager and asked, why are you paying me so much? Because I just felt serving, and I work in the public, so I just felt serving the public. And I thought this was great, I was getting paid and so much.
And that was the government.
My sister became a clinical gastroenterologist. She is much wealthier than I am, but she became one for the right reasons because she wanted to be a healer. You just have to do what you love.
We have a question here.
So my question is, among the two, both attaining a foreign degree in law or attaining a degree here, what do you guys suggest is more efficient and for us as students?
Efficient or better?
Better. The better option.
Well, the better option is case specific. It's what suits you, and it depends on all of your individual circumstances. So come and talk to one of the people in this group. I recommend Professor Kissoon because he's been a lawyer for so long and didn't have his career short-circuited by doing something else, and get advice that's specific to you. The other thing too is, if any of you do a foreign degree and come and do the LLM at Osgood, there are some really good people there that you can talk to that have had a lot of experience and know about the experience of other students. So I'm not volunteering to refer you to them, but it's easy enough to find out who they are. And if you have any difficulty, let me know and I'll tell you who they are and give you their phone numbers.
So we have one question here, and then we have Sam at the back who also has a question. Sir?
Yeah, hi, my name is Siddharth, and it was a pleasure the way you kind of conducted the session, so thanks for that. I personally work in the tech area. I'm talking on behalf of my brother, who is a foreign trained lawyer back in India, and he got his Canadian PR. He had a history of working, he did a decent education back in India from one of the national law universities there. He was practicing in one of the leading firms back in India, and he started his own freelancing on mostly succession and estate planning. He took just freelancing work for a while, and now when he comes to Canada PR, I think there was a lot of discussion on the NCA programs or the LLM courses. Is it advised he just becomes a legal assistant just to start somewhere there, or is there any career path that is recommended for his kind of scenario?
Depends upon the deepness of his pocket. If he can afford to go back to school and requalify as a lawyer, it opens many more doors. If, unfortunately, he's not rich and he needs to earn an income, sometimes people get in wherever they can and then eventually go back to school. That would be my recommendation. If you can afford it, try and get into school and requalify as quickly as possible.
Got it. So just a follow-up question, how much, when you say the education in terms of the pockets might be here?
The law schools from Osgood Hall, I think they're about 28,000 a year. Queens is about 22, so that's what you're looking at in terms of legal fees, plus residence and all kinds of other things.
Okay, and these are for LLM courses, I think you're referring to.
LLM courses might be a bit more. Okay, Sam?
The accounting profession has a co-op and summer school program whereby students leave for 3 months, 6 months respectively, and they work with a professional firm. Is there something similar that students in the legal, on the legal side can pursue, or is available to them?
We don't have the equivalent of a co-op program. We have the articling program. Some firms pay a lot more than others, and it's a debate that's going on in the Law Society at the moment with respect to the pay scale for students. But in terms of a co-op program per se, we don't have that. Not yet anyway.
If I can interject, I believe you want to look into Metropolitan University, which used to be Ronison. I understand they started something like a co-op, and I was speaking to a father of one of the students. She's very, very happy, very brilliant girl, but there seems to be something similar to co-op, so you may want to look into Metropolitan University.
TMU has sent some students from that program that's similar to a co-op program to us at the Ontario Court of Justice, and they're really enjoying the experience.
So I don't know everything. Any other questions? It is 15 minutes or thereabouts after 12, and we promised we were going to finish then. We will leave 15, 20 minutes for private discussions. I understand there's a thank you ceremony or presentation. Where is...
So at this time, it is my pleasure to call upon two other people who've been helping us to put together this conference. It's Shanti Sharma and I believe Adina Prasad, and of course Vijayanti as well, and Kumar, to come on the stage and to give the vote of thanks, along with Professor Kissoon.
So while Shanti's coming up with the tokens, thank you very much to the audience for coming out for this informative and very important session, the one on domestic violence, which we think it's important for our community to create awareness and build awareness on that, and even for the young people who are listening in, so they can, when they see something like that happening, they know what's going to be expected from that point of view when it's reported and all that. To the students, thanks for coming out. You guys are awesome, and we are about to give the tokens out. The first one is Crown Attorney Rashmi Kumar. You can go up and give it to her.
So Rashmi, so instead of me repeating the speech for all the presenters, let me say this. We were fortunate to be able to attract this caliber of presenters. These ladies took the time off on a Saturday morning when it was raining. They could have slept in, they could have been writing judgments. They don't write judgment anymore, they athletic. The Crown Attorney, she had a long day yesterday. She was in court until 5 something. I got an email from her fairly late. The other lady left her children's spelling bee to be here. These are professionals who are committed to the profession. Equally, they're committed to the community. For them to take time to be in this forum on this day to share their knowledge and the information that they can provide to us. It is my sincere hope that each of you who attended here today, you are educated, you are leaving here with some information that you did not have when you arrived here. And I must thank you for taking the time out, for coming here, because it's a difficult morning to wake up and come out here. And finally, to the organizers of this event, these ladies behind the scene from the Lakshmi Sabha worked tirelessly to put this together, and in my view, it went off flawlessly. Give them a big hand.
And thank you, Mr. Daman Kissoon. I mean, you were the instigator, and you saw the value of having this, and it is very valuable. So thank you, and hope we can have many more sessions in the future. I want to present the rest of the tokens, and the other one is going to go to Justice Sheila Ray. Thank you very much for coming out. The next one is Sonia Kimani. Thank you so much. I really enjoyed the family side of it. And Mr. Daman Kissoon, of course, with you. And so before we leave today, another set of housekeeping, please. We're all volunteers here, so please just clean up and pick up after yourself and put it in the garbage. Right? And hope to see you again soon, either in the Mandir or any of our events.
And just before we leave, we want to thank the people who came from the collateral agencies. We heard the Yellow Brick House, Children's Aid, Craftsman Center, Probation, all of you made a difference with respect to the degree of success with respect to this event. Thank you, thank you, thank you.
Thank you so much for the community support. I can't overemphasize having the other temples here, other organizations. I really appreciate you. Just to make a phone call. I see Rameshwar when they're looking at the when they were here. There's here, and who else is here? GTA Rangers. If I didn't call your name, please don't take it as an offense. We sincerely appreciate your support. If you're interested in the emotional health, mental health profession, please speak to me afterwards.